Hello, everyone. Welcome to the webinar on emergency legislation, global legislative responses to coronavirus, established by the Bingham Center for the Rule of Law, which is part of the British Institute of International and Comparative Law. Let me start by thanking, first of all, the journal, Theory and Practice of Legislation, one of the most progressive and innovative journals in the area of legislative studies, with a great focus on theoretical but also practical pieces on legislation and lawmaking. Of course, thank the Bingham Center for the Rule of Law at the British Institute of International and Comparative Law. Thank our peer reviewers for the incredible work they've done, and of course, EFISHI for doing the heavy lifting on organizing the special issue. Of course, thank our speakers, and I will be presenting them in due course, and the event conveners, Dr. Ronan Cormacain from the Bingham Center for the Rule of Law at BICO, and Dr. Itai Bar Simantov from Bar Ilan University in Israel. Before I start, and I will be reminding this to you again, diary date for the next seminar is on the 14th of July, and we will announce further details further on. So let me start with the introductions. I am Professor Helen Zamtharki. I'm the Dean of Postgraduate Laws at the University of London. I'm a professor at UCL, and I'm the president of the International Association for Legislation. Also to declare that I am one of the lovely company of editors of TP Ledge, so I have an interest there. We have a select panel of speakers, all very eminent in their fields, and most importantly, sharing with us new original entries of their, or records of their work in quite a developing issue. And in that respect, I very much look forward to hearing all of them. I will introduce them now. We have with us Professor Patricia Popelier of the University of Antwerp, and Patricia will talk to us today about emergency legislation in Belgium at the crossroads of a political and a health crisis. We then have Mame Efua Adazi Kum from the Faculty of Law of KNUST in Ghana, going to talk to us about quasi-state of emergency, accessing the constitutionality of Ghana's legislative response to COVID-19. We'll then continue with Professor Felix Uhlmann of the University of Zurich, legislative response to coronavirus in Switzerland. Then we have Professor Klaus Messerschmidt, Humboldt University of Berlin, and Friedrich Alexander Universität Erlangen-Nuremberg, going to talk to us about COVID-19 legislation in the light of the precautionary principle. Then to be followed by our Brazilian group, so Dr. Marcelo Ilaras, Victor Pineiro, and Melissa Terni Mestrine was going to talk to us about the impacts of the COVID-19 crisis on the Brazilian legal system, a report on the functioning of the branches of the government and on the legal scrutiny of their activities. And we will close with our Hungarian group, Professor Timea Trinosi, the University of Pécs, and Dr. Agnieszka Ben-Kasala of the Universität Mikołaja Kopernika w Toruniu, who's going to talk to us about COVID-19 on a comparative basis between Hungary and Poland, extraordinary situation, and illiberal constitutionalism. So we're very much looking forward to hear each and every one of them. Just to talk to you about how this will be organized, we will keep our audio and video switched off, even as panelists, so that we can accommodate the large number of participants that are with us today. I will give 10 minutes per paper to each of the panelists, and then I will allow 5 minutes of questions that will be asked via myself. So if you have a question, I suggest that you prepare and you raise your hand so that I can come with you at the end of each paper. We will finish with a concluding talk, and my aim is to keep to time, panelists, and conclude on time. So very much looking forward to starting. And on that note, let me invite Patricia, Professor Popelier, to start.
Thank you very much. Are you all seeing the slides now?
We can see the slides. I would appreciate it if you had your volume a little bit up, because it's quite difficult to hear you, Patricia.
Is this better? Is it better like this? Helen?
Yes, it is better. Yes, thank you.
Okay. I don't know what the slides are doing now, but anyway. First of all, thanks to Roman and Itai for organizing this, and to all the people that gave their support. Now, this seminar examines the corona crisis from the angle of legislation. Emergency legislation usually brings about a centralization of powers in the hands of the government. And that sets aside Parliament, which raises questions of democracy and legitimacy. Now, the Belgian case is in particular interesting from that perspective, because the health crisis emerged in the middle of a political crisis, and what even may grow into a regime crisis. Now, in that case, the centralization of powers in the hands of the executive means a power boost for a government that represents only a quarter of the Belgian electorate. And this minority government that was turned into a temporary emergency government took measures that impacted very drastically on citizens' personal and social lives, their fundamental rights, the entire economy. And yet, in a first phase, citizens' trust in the government was unusually high, and even higher than in the surrounding countries. Then in a second phase, this decreased again, but not lower than what we're used to. So it remains a very interesting observation. There was distrust between political parties and between major language groups, to the point that after a year, no agreement for a new government could be found. And yet there was a general support from these same parties and from the population to entrust a resigning minority government with huge powers to organize an entire lockdown. I'm trying to change the slides, but it's not possible. So let's just do without them. Okay. Yes, thank you very much. So the big question is, how does, no, now everything is coming. That's the one. The big question is, how does a minority government in the middle of a political crisis create enough legitimacy to steer the country through a worldwide health crisis? And important in the current phase, how does it keep this legitimacy? I will not keep you in tension, but give away my conclusion right away. In my view, the political crisis gave opportunities to safeguard democracy more than would have been possible otherwise. But at the same time, it was a temporary thing, and the political crisis will complicate things in the next phase. My starting point was the relation between representative democracy and legitimacy in terms of input, output, and throughput legitimacy. This notion of legitimacy was created for the sake of the European Union as an alternative for the traditional state-centered concept of representative democracy. But my contention is that representative democracy is not enough. It covers input legitimacy, but a mature democracy needs input, output, and throughput legitimacy. And even more, in a mature democracy, this is not assumed. It can be tested in court. But that's a different story. Input, output, and throughput legitimacy can be realized in different ways, and different combinations of these types of legitimacy are thinkable. But where input legitimacy decreases because Parliament is set aside, the other forms of legitimacy become more important. So what I want to do now is discuss the Belgian case from the angle of these types of legitimacy and examine what impact the political crisis had on this. So first, input legitimacy. This refers to the people's participation in decision-making. This puts the spotlights on the role of Parliament and on the consultation of stakeholders. To start with a letter, this was quite problematic. An emergency situation means that there is not much time to consult, and it's especially so in the first phase with the lockdown and preventive measures. It is different in the second phase when these measures are relaxed, but still stakeholders were sometimes overlooked. For example, when the government first announced that the visit ban in retirement homes was relaxed, there was a loud protest from the residential care sector, and the government shamefully had to admit they had not talked this through with the healthcare sector. Parliament then, first of all, Parliament kept functioning. The ministerial emergency decree clarified that legislative powers and their services were considered essential services, which means that they did not have to close. Procedural rules were adjusted to enable electronic votes. Live meetings were also held, but for example, in plenary, only 2 members per fraction were allowed. Of course, this complicates parliamentary debate, but the bottom line is Parliament worked. The government was questioned every week, and several measures, mostly support measures, were enacted in Parliament. And this might be surprising because Parliament had issued a special powers law. And that law gave the government special powers to take all the measures that were needed to fight the virus, but also to moderate the economic and social consequences. And these measures could even bypass an act of Parliament. So we did not need acts of Parliament, but Parliament still remained in the picture precisely because the government did not rely on majority. The Special Powers Act requires that the government decrees are afterwards confirmed by Parliament, but if there is no majority, there's always the risk that decrees are going to be debated and confirmation denied. So it's better to get the measures through Parliament at once, now that there is still a sense of emergency. In as far as special powers were used, there was a special informal arrangement that was unusual. There is no precedent for this. And this arrangement is that each special powers decree had to be discussed in weekly meetings with the party leaders and 1 fraction leader of the 10 political parties that supported the Special Powers Act. Of course, it's not the same as discussing in Parliament. Only 3 of these watchdogs were MPs. But this was most of all the blunt admission that Belgian democracy is really a partytocracy. On the other hand, this gave opposition parties access to the central decision-making during the corona crisis more than they could ever dream of in ordinary health crisis situations. On the other hand, let's not make too much of this. In the end, the most radical measures, the ones that imposed the lockdown and the exit strategy measures, were not issued through special powers laws. Everyone discussed the special powers, but in reality, these measures rely on a simple ministerial decree. The legal basis of that one is questionable, but no one questioned it. And the government was happy to use it to avoid all the fuss surrounding the special powers track with the 10 watchdogs and the need of confirmation by Parliament. So there was a decrease of parliamentary involvement there. So let's look at the other types of legitimacy. And throughput legitimacy is about the process and how it helps to translate input into effective outcomes. And here something interesting happens. Experts were brought in. You see them on the slide. In ordinary times, consociational politics in Belgium do not leave much room for expertise. Politics come first. This time, most government decisions were based on expert advice, and experts also took care of most of the crisis communication. This was also the case elsewhere, but in Belgium, experts were relied on more heavily, and politicians remained more in the background. Decreased representative legitimacy was compensated by increased rationality, and the population appreciated this. It trusted and kept trusting the experts most of all, and they trust the government because the government relies on experts. And this was in particular the case in the first phase, when health prevention has priority. It gets more difficult in the second phase, when measures are relaxed to enable a restart of economic life and social life. An exit strategy cannot rely on medical and biological expertise alone. It needs a variety of disciplines, and there are more possibilities, so no consensus anymore of what is the best way to go. An exit strategy and supporting social economic measures imply fundamental policy options and an imagining of the society to come. In the first phase, the Belgian welfare state provided enough safety nets to overcome this, But that's no longer the case now that we begin to see the full impact of the corona crisis. At the same time, legal advice was largely ignored. The ministerial decrees were issued without a legal opinion of the Council of State Division legislation, and when a case was brought before the Court of State Division administration, the Council gave the government the broadest possible discretion. It did not want to stand in the way. At the same time, it did emphasize the fact that the measure that was challenged relied on expert advice. So expert advice was also important from a legal angle. As to output legitimacy, the corona crisis dominated people's daily lives and was the almost exclusive topic in the news for a long time. The people's behavior and the news comment then functioned as barometers for output legitimacy. Again, we noticed two phases. In phase one, the stringent measures were well complied with, and with results, little more than 3 weeks after the first fatality, a stagnation in the growth was reached, and since then the curve continues to fall. This can be seen as signs of output legitimacy, and this is confirmed by the high level of trust by the population, which has been tested the whole time. At the same time, the declining trust shows that it is not easy to sustain this high level of trust. As soon as no urgency is felt anymore, citizens become more critical and they do not obey so easily anymore. Especially when we'll have to discuss how to manage the budget and how to rebuild society and the economy, output legitimacy will require a closer link with input and throughput legitimacy. The involvement of Parliament that is representative of the population and therefore has the legitimacy to make fundamental ideological choices is important. And also the involvement of an interdisciplinary set of experts that enable Parliament to make informed choices. So, conclusion. The political parties realize this. What you see here on the slide are the party leaders of 3 different parties who, again, once more, are trying to form a government. No luck so far. Steps are being taken. But the antagonism is so deep that it is unlikely that they will succeed this time, despite or even because of the current situation and all that is at stake. So the political crisis has not hindered a more or less efficient and legitimate first response to the health crisis, but there is no guarantee for an equally adequate long-term approach. Thank you.
Thank you very much, Patricia. I think at this point we can all clap, even though I think you can only hear me. But I think it was a wonderful picture of what happened in Belgium. And I found quite a few characteristics that were different to what I had in mind. Just to remind everyone, we have more than 90 participants right now, 90. So could I please ask you to use the box at the bottom of your screen, Q&A. If you place your questions there, then I would be delighted to read them out. But let me start you, Patricia, with a question from Dr. Comacane Ronan. He's asking you this: do you think that there's a link between Belgium's poor record on infections and deaths and its legislative response to the crisis?
Well, I don't think really that there is we were late. So in the beginning, we had politicians had their minds elsewhere because they were trying to form a government after, yeah, I mean, for a year already. But so we were late. But the reason why we have such high numbers of infections and that's is one of the reasons is that we just gave another calculation, because most countries only counted the deaths in the hospitals, and we added to that the deaths in the residential care but there was still, we were still, even if we calculate that in, we were not doing very great, but not that bad. And then I think it's also just bad luck, and where the most infections were situated in not all the residential care homes, but some of them, and that was a problem. And the biggest problem of all was that we were so poorly prepared. We had no stock whatsoever. So we could not start with testing. We could not even provide sufficient medical protection for the carers in the residential homes. The hospitals were fine. We had no problem there at all. And then all the focus was on the hospitals. But in the meantime, things were going on in residential care centers, and we were just too late to that. I don't think it's really the legislative response. It also has to do with the past and with politics being more concerned with party politics than with just preparing for the future.
Can I ask one question? From a constitutional perspective, I found it very interesting what you said, that a lot of things were done via legislation, so through Parliament, whereas my experience, well, at least in Greece, but also I think in the UK, and I can stand corrected, was that what I observed was the executive usurping the responsibility and the legislation with it. Why do you think Belgium was different? Can you, I know that you've said a couple of things, but expand a bit more for me, please.
Because it was a minority government, so they were very, very closely watched. The parties weren't able to form a real government. So they said, okay, we don't really trust you. We haven't for a long time, but we will give you our confidence, but just for a short time. And we will give you special powers, but they have to be confirmed afterwards. And we're not sure if we're going to extend it after 3 months. Now, if you have to have these special decrees confirmed afterwards, when there's no sense of urgency anymore, there's going to be a problem. Also, you have to, there was these 10 party leaders that were coming and were looking at these decrees, so it couldn't go that fast. So the idea was in the end, well, we can just as well go to Parliament.
Brilliant. We have another 2 questions, and I'm afraid only 1 minute to answer them. So do you want them both? Or let me start with Sven Sifken, who's asking, what was the role of the subnational governments in crisis response, and how much variety was there?
Okay, not much. That was very surprising, but it's a different paper. It's a totally different story, but there was a lot of centralization immediately. And that was very surprising because we are in very decentralized dynamics. And at the time, there was a proposal for confederalism on the table even. And then there was not even a sound basis for central uniformization, but it happened and no one complained. But there were problems in coordination, etc. But the communities and the regions decided they needed to have a uniform reply. So there is a lot of, they tried to do everything the same. For example, the Flemings wanted to leave the schools open. The French-speaking look at France, and as soon as France shut the schools, they wanted to do it as well. So in the end, we also closed schools. So there was, but one of the reasons is that they have competence in Brussels, both of them. So if you would have variety, that would mean that in one street, the school would be open, and on the other street, the school or the library or whatever would be closed. And that would just make no sense if health and the virus is the reason for closing.
If we move quite quickly to Afila, what are the upcoming strategies at national and EU level to combat the virus and re-establish traditional legitimacy of Parliament at the same time in the future? I'll give you less than 1 minute, Patricia.
I'm not sure what the question is.
So what are the upcoming strategies at national and at EU level to combat the virus and re-establish traditional legitimacy of Parliament at the same time in the future?
The upcoming strategy, at this point of time, the only strategy I see is trying to form a government, which is really difficult. And other strategies, well, everyone has different opinions. Some want to centralize the whole health sector, others want to decentralize the whole health sector, but I'm afraid we didn't come further than that.
Thank you. Thank you very much, Patricia. I think we can take more questions later on, but it's time to now move on from Belgium to Ghana and talk about the quasi-state of emergency assessing the constitutionality of Ghana's legislative response to COVID-19. And could I invite our colleague Mame Efwa Adatsi Kum to please take the floor.
All right, thank you. Presenting on the quasi-state of emergency and assessing Ghana's legislative response to COVID-19. What happened in Ghana was that when the coronavirus hit Ghana, an emergency legislation was passed, which was the Imposition of Restrictions Act, which was passed. Now, the Imposition of Restrictions Act is a very short enactment, just has about 7 sections, because it leases out most of its powers to the president, who would then detail further directives through executive instruments. So the act, so just briefly about the act, even though the act was triggered by the coronavirus, the act does not mention coronavirus anywhere. It's only a generic act that covers emergencies. And so it's an act that will survive the pandemic even after all of this blows over. The act will still be there. The thing of what's the challenge with the act is that it gives the president unrestrained powers, and so the president has the power to give any directives, and he doesn't have any accountability at any levels. So the act only says as far as that the president has to consult a relevant person or a relevant body. Who that relevant person or that relevant body is, we do not know. It could be anybody, his mother, his wife, his uncle, his secretary, anybody could be a relevant person or relevant body. And it also gives a blanket punishment. So then within that act, you have the minimum punishment being 4 years imprisonment, the maximum being 10 years in jail, or if it's a fine, the equivalent of $2,000 US, the minimum, and $10,000 US for the minimum. And that's a blanket punishment. So it doesn't matter how little or how small an offense is. For example, to put it in context, for now, the president has released an executive instrument making the wearing of masks an offense. If you don't wear masks, it's an offense. Now, if looking at it in the context of the range for punishment that the president has given, it means that if you are found wanting for not wearing a mask, for example, you could go to jail for 4 years, or you could be fined $2,000 US, which is absurd. And so that's another challenge with the act. And then the act also doesn't have an expiry date. It doesn't have any sunset clause that says this act exists until this particular time, maybe when the pandemic is declared officially over or whatever time. And so it exists and is going to be there, and it can be applied to any situation outside of a public health emergency or outside of a pandemic. Now, the act draws its authority, constitutional authority, from the constitutional provisions that limit fundamental human rights. And the limitations for those fundamental human rights are intended to be used during normal times and not during emergency times as we are in. And so, which is why I titled my paper The Quasi-State of Emergency, because we have an emergency legislation that is given the president emergency powers. Yes, those emergency powers are being draw their authority from a source that intends those powers to be used within a normal time. And so it's like we have exercising emergency powers without declaring any emergency, and so there's a confusion, and so it puts a lot of structures when it comes to even democratic governance in question, because when is this health related? When are we supposed to question or make the president accountable for this action or for this directive? And when are we supposed to step back because he's doing it in the interest of the country for the sake of the emergency that we have at hand? And so in the paper, I draw the distinction between emergency powers when it is exercised for the purposes of derogating from fundamental human rights, and those that are limitations that exist in virtually every constitutional setup for normal times, because most of the rights are not absolute, if I should put it. So, and that is where my assessment of the fact that the legislation is not constitutional comes in, because if you look at the Constitution itself, the Constitution has provisions for handling situations like this. The Constitution makes room for declaring a state of emergency, and this is how it works. If the president should declare a state of emergency in response to the pandemic, then he would have Parliament being accountable. He will be accountable to Parliament. So then he would have to come to Parliament for the initial declaration of a state of emergency, whatever directive he gives will work for a period of 3 months. And then after the 3 months expires, you have to go to Parliament, and they will extend it on a monthly basis. So you have Parliament being a check on the president. But with the current emergency legislation that we have, which is the Imposition of Restrictions Act, we do not have any such accountability. And so the president can, in the comfort of his home, decide that this is the new directive that is going up, and this is how long it is going to be in existence for. And Parliament has ceded or has given president all the powers, and so he does not need, or he will not go to Parliament for any consultation. There is no accountability, there is no check. It's a highway, an endless highway that he's on, and he can speed as much as he wants. And the concern here is the fact that
just you have
sure,
one.
I'm almost done. I'm actually done. Almost done. All right. So in the paper I made the conclusion that because of the unconstitutionality, aside the unconstitutionality of it, and considering that Ghana we've had a series of coup d'etats, considering our constitutional history and the fact that powers are subject to abuse by president, have been abused by presidents in the past, it's important that we quickly set the record straight, because even if that doesn't happen in this coronavirus pandemic, after that, we can be there one day that any president at all could act on the authority of that emergency legislation and say, hey, this is an emergency, this is what I want to do, and nobody can stop him because he has that legal backing. And so I recommend that through judicial review, we can set the record straight and make sure that we continue to respect constitutionality. Thank you.
Thank you so much for, I think I reflect everybody's gratitude for presenting to us the Ghanaian position. It doesn't quite come through that often in the UK, and it always gives us food for thought and models to follow. I'm a big fan of Ghanaian legislation. So I have a question to start with from Dr. Cormacain. So Ronan wants to ask, and I share his view, that the penalties seem disproportionate and the law doesn't have a time limit. Do you think this breaks good lawmaking practice for emergencies? And if I can add to it, I see again that the main resort of the legislator was, again, criminal offenses and harsh penalties. I'm not quite sure that within the Ghanaian context it is they are disproportionate, because compared to the UK, your criminal law concept is a bit heavier handed. Do you think, thinking back, that this was necessary, and is there any other non-criminal solution that the regulators could have put forward?
Yes, I think that first of all, I think the legislation was not necessary. I think the punishments in there are way too high, because for the fines, the average Ghanaian cannot even pay that fine of $2,000 US. The average Ghanaian cannot pay it, where the price of the mask, the locally made mask, costs less than $1. So if somebody doesn't wear a mask that costs less than $1 and you are fining them $2,000, where are they going to get it from? So it's just, and I think it's also because we didn't anticipate that it should be a crime not to wear a mask. So now that it's a crime, then the legislators would have to go back and check. So they realize that, yes, there's parity and there's proportionality between the offenses that have been set and the punishments that are available.
Thank you. Thank you very much. If there are no further questions, I think it is a reflection on how detailed and complete your presentation was. So thank you very much for it. And again, any questions, participants, we can come back at the end of the speakers. Time now then to move on to Professor Ullman, Felix Ullman, who is going to talk to us about the COVID-19 legislation, about legislative response to the coronavirus in Switzerland. On to Felix, please.
Yes, hello, Helen. Hello, everyone. Thank you very much to the Bingham Center for the Rule of Law and the Journal Theory, Practice and Legislation for inviting me to share some thoughts on the legislative responses to coronavirus in Switzerland. hopefully you see now the shares as well. If I don't hear any protests, I hope you can see it. And let me just go through some constitutional points that are maybe helpful just to see the background in Switzerland. In times of crisis, important decisions must be taken quickly, usually at least. And typically such powers shift to the executive branch, and Switzerland is no exception to that. You see one of the main provision, Article 185, paragraph 3. According to this provision, the Swiss Federal Council, that means the executive branch, may issue ordinances and administrative acts in order to counter existing or imminent threats of serious disruptions to public order or internal or external security. It is undisputed that the current pandemic qualifies as an imminent threat of serious disruption to public order or internal or external security under this article. It is less certain that whether the Constitution not only allows the classical police measures, the curfew and things like these, but also financial ones aiming to address the social and economic hardship that follows from the lockdown. The Swiss Federal Council has invoked this provision in order, for example, to support the Swiss bank UBS back in 2008. Many doubted that this was constitutional viable, but still it was accepted, and it's accepted again that now under the current crisis, the Federal Council, the executive branch, is invoking this norm of 185 paragraph 3. So when we just look at the Constitution, why do we need Parliament? And indeed, it's maybe not a coincidence that the Federal Parliament was in session during the height of the crisis. On March 15, the offices of both chambers decided to abort the session, although one chamber at the beginning of the same week had still explicitly rejected such a motion. The offices also suspended all committee meetings. The decisions of the offices attracted widespread criticism. It is doubtful that these decisions were legally correct. The offices of the chambers have mainly administrative function, and their members do not enjoy superior authority compared to the other MPs. And also from the sign you had actually in Switzerland the executive branch and the executive branch only, and it looked like a parliament was going to a recess at the height of the crisis. So why do we actually need parliament in Switzerland? In my opinion, and I think also during the crisis, many other scholars, we are of the opinion indeed that parliament is needed. Needed because of the role of approval, of oversight, and also enacting emergency legislation in its own right. I believe that the legitimacy of the executive branch goes only as far as Parliament is not able to react, because still important decisions, especially how much money you spend, also in the time of crisis must be taken by Parliament. The delimitation of powers between the executive and the legislative branch depends on the need of imminent action. If you need imminent action, if you need a lockdown, the Parliament is too slow. If you want to decide measures that will take 2 or 3 years, then of course it's the powers of Parliament to intervene and also possibly to correct the executive branch. So once we have established the role, there are some technicalities that shouldn't be underestimated. For first and foremost, the right to convene. On the federal level, the competence of Parliament to decide on its sessions was never put in question. However, on the cantonal level, on the state level, the exact same question was debated. The Parliament of the Canton of Zurich was denied an exceptional permit by the local health department, based on expert opinion. And maybe that's good news for Patricia Popperly. Sometimes in Switzerland, politicians listen to expert opinions. So based on an expert opinion, the office of the Kantonsrat protested, and the cantonal executive quickly confirmed that the Kantonsrat itself was in charge to allow for an exception, thereby following the argument that the separation of powers implied that each power decided by itself and under what form it shall convene. In Zurich, the session of parliament was particularly relevant as the cantonal constitution required immediate approval of any emergency ordinances enacted by governments. So it was clear from a separation of powers argument that we need parliament to allow the government to take certain measures. Last but not least, how should parliament convene? Do we prefer a limited composition in large halls or video conferences? Well, quickly, everybody found out that actually that there is just no legal basis for parliament to convene electronically. So the alternative that was taken is just to rent these large halls. But even so, I think from the constitutional point, we have some problems. Because in Switzerland, and I suppose in many other countries, the particularly vulnerable persons should stay at home. And staying at home really means staying at home. And even if the particularly vulnerable people are members of parliament, they actually should stay at home. On the other hand, if you're a member of parliament, you have some kind of duty, or you have a duty to go to a parliamentary session. So there is some kind of tension, if not a contradiction. Either we have a parliament that has a composition that is, to say the least, biased, because we have excluded the vulnerable people, the elderly people, we exclude the ill people, which I suppose under many constitutions is a problem if we discriminate against these groups. On the other hand, if everybody is attending, then it sends a very bad sign that obviously even for the vulnerable people, it's not so dangerous to go to these sessions. So we have also, however we do it, I think we have some kind of problem. It's clear one of the lessons is that the parliament will enact some rules to allow video conferences in the time of crisis, but as long as we don't have this rule, we have the problem. Either you have a strange composition of the parliament, or you have people that probably shouldn't go to parliamentary sessions. These were my thoughts, and I just give to Helen. It was very quiet, and I hope you could hear and see everything, and I give back to Helen.
Thank you. Thank you very much for responding in a Swiss way. No reaction, you just did what needed to be done. So it was a fantastic presentation, a completely different angle. I've got three questions. So let me start with the audience and then I will give you mine. So Mandy Brownen, for all speakers, at the end of their presentations, is it better for the rule of law to formally declare a state of emergency and use those powers, or not to do so with the risk that non-emergency powers will be stretched in a dangerously precedent-setting way? So what do you think, Felix? Do you want
it's a tough call. I mean, from Switzerland, we have maybe the strange legal background that actually it's government itself that may declare the state of emergency by itself. And we don't have some empowerment by parliament. Funnily, we had that during the Second World War, but it got some kind of forgotten. I'm not sure, probably because we have quite a lot of comparison between all the cantons, the states. I would say maybe the best model is that we see in some cantons that you have that actually it's the executive branch that can react quickly, but as quickly as possible, we have also some kind of approval by parliament. I think that's probably the model that would be preferred in Switzerland after the crisis. At least people thinking about this question are preferring this model, but that may work for Switzerland, may not work for other countries.
Thank you. Moving on to Ronan's question, you mentioned the criticisms on the decision to close parliament. Was this criticism focused on the process for making the decision, or also on the substance of the decision itself? That is, was it generally accepted that the decision to suspend Parliament for such a long time was justified due to the health crisis, or was it viewed as an unjustified overreaction?
Actually, both. I think it was some kind of overreaction. They just panicked. And of course, the sign was a little bit strange that the government was working, Parliament is going to holidays. That was probably politically not ideal, to say the least. And there was also some technicalities that just the offices were not competent. And if you want to read about this, there's more in the paper about it. But it's also another problem that there's actually no, let's say, some central power in Parliament that can decide. I mean, that's another aspect of the problem. This formal aspect shouldn't be underestimated.
Mm-hmm. I was, and I'll finish, I think, with that question. I was quite interested in the fact that you felt that Parliament could not meet electronically. And I find it quite interesting because for me, this is not, it doesn't sound to me as if this is a constitutional safeguard to ensure that Parliament sits properly, if you know what I mean. So can you expand on this a little bit more? Is it really just a technicality, or do you see an actual substantive administrative constitutional essence to it?
Well, the problem is on the federal level, the provision in place was always understood that it's really a physical meeting, and a physical meeting only for traditional reasons, etc., etc. So we actually indeed had a constitutional problem doing otherwise. I mean, it was kind of a joke, I think, because I mean, physical presence meant that you are in the Parliament building, but not in the Parliament hall. So you just can go to drink a coffee, not listen to anyone. That was constitutionally permissible, but electronic conferences were not constitutionally permissible. There we had some, well, discrepancies, to say the least.
Yeah, as you were talking, I was thinking in my brain as somebody living in the UK, so is Parliament an essential shop? Does it close during lockdown or not? Thank you so much. It was a fantastic presentation as usual, very much to the point. And I think it brought a topic into light that I had not thought about before. Once again, you've enlightened me. Thank you very much. Let's now move on to Professor Klaus Messerschmidt, who's going to talk to us about COVID-19 legislation in the light of the precautionary principle. So Klaus, would you like to have the floor, please?
Do you hear me already?
Very well, loud and clear, and we can see.
Thank you very much. Thanks.
Yes.
Sorry. Thanks to all of you, to TP Ledge, Bingham Center, and to our excellent moderator. I'm not talking in particular on Germany, but try to concentrate on some more general aspects and taking European law as an example. In the still persistent COVID-19 crisis, most states justify laws and measures which restrict a wide range of fundamental rights and freedoms to a hitherto unknown extent, with the argument of an acute public health threat. The precautionary principle is used to close gaps in justification that arise from the partial lack of evidence. You may compare its role to a reserve player. The principle facilitates the enactment of laws of fear. Sunstein says so too. Above all, however, I could not resist the temptation to benefit from the cover of his book. I owe Ronan Carmichael the knowledge of the following example from the recent High Court case law on COVID-19 management in the UK. I think I'm a bit too fast now. No, I think I changed it. Only read the last line. It is written by the judge in this case, and it says, "The Secretary of State is entitled, in my view, to adopt a precautionary stance." So perhaps the precautionary principle is a bit trivial, but it has some far-reaching impact. So let's look for a definition of the precautionary principle. The best and best known definition of the principle was proposed by the European Court of Justice in the National Farmers Union case. I quote, "Where there is uncertainty as to the existence of the extent of risks to human health, the institutions may take protective measures without having to wait until the reality and seriousness of those risks becoming fully apparent." In view of the many controversies among, and this is the end of the quote, and this is the comment, in view of the many controversies among experts, there are often uncertainties that make it necessary, or at least attractive, to resort to the precautionary principle. I asked one of my research assistants to check the role of the precautionary principle in German case law. She came up with not too many results, although there are a lot of adjudication. So they mention the precautionary principle only in a superfluous way, because of course it is more attractive to rely on imminent and present danger than on precaution. But nevertheless, in the same way as in the High Court decision, it is their sort of fleeting being. So we already had this. Now let's have a look at the scope of the precautionary principle. The principle plays a role at several levels: in international law, in union law, and in national law. If I knew about the presence of our Brazilian friends, I would have concentrated on the Rio Declaration, but I think we can look it up. I think it's Principle 15, something like that. The presentation focuses on EU law, since the legalization of the principle is the most advanced there, and we have brought case law. I do not want to scare you with the precautionary principle. If you Google the term, you would get 11,100,000 results within 0.38 seconds. In the face of this tsunami, I neither promise nor threaten to develop a new theory. I'm just trying to relate it to the pandemic situation and to outline some of the major legal risks. Due to the emphasis on the principle in Article 191, Paragraph 2 of the Treaty of the European Union, it is particularly linked to environmental law. However, it also plays a role in public health law and can, as in the National Farmers Union decision, and it can be transferred to pandemics. A cascade of problems connects with the intuitively convincing maxim, better safe than sorry. First, a shift of the burden of proof. Think of the NED versus END controversy. The statement, no evidence of disease, makes sense, whereas evidence of no disease is hardly available. Second, a partial departure of the maxim of evidence-based lawmaking. In the precautionary situation, there is per definitionem no full evidence. Suspicion may be enough. Third, a weakening of the reason-giving requirement. Lawyers in many countries are fighting for it. Fourth, a challenge to the rule of law. Imagine someone proposing to apply the principle to the fight against crime. Followers and opponents would be very different from those in the pertinent debate on environmental and pandemics law. The link between the rule of law and the notion of evidence-based lawmaking can be explained by the concept that infringements of individual rights must be justified by legal norms and established facts. I do not pronounce the German word in an English way. Here I refer to the famous and infamous Carl Schmitt, the Dr. Jekyll and Mr. Hyde of German constitutional law, and I ask for your indulgence for this frivolous metaphor. Despite his later involvement in the Third Reich, he had previously gained some groundbreaking insights that contradicted his other beliefs. This is one of them. So I pronounce it now the rechtsstaatliches Verteilungsprinzip. And I like it very much because it creates a link to the burden of proof. I come to my conclusions. As a result, a generous application of the precautionary principle puts at stake key achievements of the rule of law and can lead, I see. So this is coming back to the NED and controversy. I think it's quite clear. Again, I try to come to my conclusions. As a result, a generous application of the precautionary principle puts at stake key achievements of the rule of law and can lead to arbitrary action. So let's come back to this picture. So I think this is the lady in red. I think she is an adherent of the precautionary principle, proof that it is safe. So no, the other way around. I think we can discuss later. I think the man in the blue suit is an adherent of the precautionary principle. So, but it's clear that it may put at stake key achievements of the rule of law and can lead to arbitrary action because it works without full evidence. In conjunction with the benefit of appreciation given to the state and the legislature anyway, and the judicial review limited to the occurrence of manifest errors, the principle of risk avoidance itself becomes a risk. A third point, it is therefore essential to maintain the primacy of the principle of proportionality to proceed upon a trial and error approach and to subject measures based on the precautionary principle to rigorous and ongoing control such as impact assessment, follow-up measures, and judicial review. Fourth and last point, the easing of the requirements for state interventions stemming from the precautionary principle only benefits preventive measures. And like what has been said before, I think, but not the mitigating and compensatory measures. And now I wanted to show you Mr. Draghi because of his famous statement that the ECB is ready to do whatever it takes to preserve the euro, but we might also say public health, not the ECB, but European governments. And I say we must not allow the whatever it takes philosophy to prevail. If you are in an emergency for the second time in a decade, and politicians feel that either a bazooka or a sleeping pill is the instrument of choice, something went wrong beforehand, but this is not the main point, the topic of my report. Thank you very much for listening to me, and I'm looking forward to the discussion. Thank you very much.
Thank you very much, Klaus. As ever, we've come to expect a fantastic presentation, and we received one, as always. I think it was very interesting to hear a principled approach to COVID-19, and there are quite a few questions. Let me start with one from Ronan. If we follow the precautionary principle for COVID-19, what safeguards should we have to prevent abuse? So what safeguards would you suggest we need to prevent the abuse of the precautionary principle? How do we balance it?
Mm-hmm. May I answer right now?
Oh, please.
Yeah, thank you very much. So actually I would join suggestions made by the other speakers already. So there should be a limitation to these powers, special powers. And I must say, maybe it also depends on the political situation. So we learn always about instability in other countries. Perhaps I think Germany suffers from a way of ultra stability. So, and I think if you face the threat, do you want to survive? So all take one, I think, uniform point of view. And we must be careful not to extend the powers that were given in the imminent emergency situation to prevail and to determine also now the mitigating and compensatory measures. Mm-hmm. So I think it depends on the political situation, and perhaps I think one question was put to Mr. Ullmann on emergency powers. So in Germany, our emergency powers are restricted to military and civil war situations. So the emergency powers provision in the Constitution does not cover catastrophes and natural disasters. So we try to solve these problems in an informal way. And I think this is very dangerous. So we must be more strict. And I think we must have the freedom to discuss the problems of fighting the pandemic in a less biased way, because in a way, if you put questions in Germany, you might be on the wrong side. So this is, I think, a severe problem. This uniformity of dealing with the COVID crisis.
Thank you so much. I think you've done an admirable job in presenting the precautionary principle, because it does, I think, and this is something that we were missing in the UK, a principled approach that could answer all those mitigating questions. If you apply it, you get answers to all your dilemmas. And I think it is also quite important that you've delimited it in a way that it doesn't become too fluid. So thank you very, very much for your insight. It was a pleasure and as always an honor to listen to you. And we'll come back with further questions at the end. Thank you. So from Germany, shall we now then move on to our Brazilian team? Marcelo and Victor, I think, will talk to us about the impacts of the COVID-19 crisis on the Brazilian legal system. So gentlemen, you have 10 minutes. I'm not going to raise the issue of the time in the 5 minutes of the first speaker. If you're a team, I will sort you out in the end. Please do have the floor. Looking forward to it.
Thank you. Let me just share my screen here.
Yes.
I think there we have it. So first and foremost, I would like to thank the Institute, the Bingham Center, and the Journal of the Theory and Practice of Legislation for putting together this seminar. Let me briefly introduce you to the co-authors of the paper we're presenting today. So Ms. Melissa Messerner is a PhD candidate at the University of São Paulo and a researcher at Fundação Getúlio Vargas. Mr. Victor Pinheiro is also a PhD candidate at the University of São Paulo and a legislative counselor at the Federal Senate in Brazil. And myself, I am a qualified lawyer in Brazil, and I did my PhD at the University of London. So let me present you with a context regarding the current health crisis in Brazil. The first victim of the coronavirus was registered in the country on 23rd January 2020. The last figures show around 55,000 casualties in Brazil and more than 1,100,000 infected people. As you can see on these graphs, Brazil is yet to reach the peak of the crisis and the peak of the number of infected people, which is even more alarming. When facing such a scenario and assessing the possible legal responses to it, one needs to bear in mind that Brazil is a federation with huge economic and social dissimilarities across its territory. In such a reality, the federal government enacted law number 13,979, which provides for legal grounds for shutdowns, quarantines, and other social distancing initiatives and related measures to tackle the health crisis. This piece of legislation works as a kind of umbrella with respect to legal measures to be adopted by both the Union, the states, and municipalities. And in spite of this, so far, there has not been direct and clear action from the federal executive in favor of social distancing and related measures. On the contrary, the main actions were taken at the state and municipal levels. Actually, the President of the Republic acted to some extent in sheer confrontation to acknowledge best practice to avoid the spread of the disease. Just to mention a few examples. The President used to be present at public gatherings and demonstrations. He encouraged people to return to their regular activities despite state and municipal social distancing measures. And he champions the use of hydroxychloroquine against the virus, even though the scientific evidence suggests it's not effective as a treatment. We need also to draw your attention to the constitutional amendment number 106, which was enacted on 7th May 2020. This so-called war amendment establishes a fiscal, financial, and public procurement regime related to the pandemic crisis and separates in the union budget the expenses related to the fight against the coronavirus. Well, the paper put forward two main arguments. First, there has been dispersed, sometimes conflicting policies about social distancing measures by federal, states, and municipalities. And second, the Brazilian Supreme Court played a major role limiting the federal executive initiative to concentrate power during the crisis. Nevertheless, no institutional disruption is observed so far in the country. We reached these conclusions by identifying and assessing two main focuses of dispute. First, the dispute considering the federative principle. There have been a series of conflicting regulations enacted by both the Union, states, and municipalities. Moreover, in fact, there have been a clear dispute on who is entitled, according to constitutional rules and constitutional principles, to enact specific provisions to tackle the problems caused by the pandemic crisis. The second focus is a dispute between the President of the Republic and the Brazilian Supreme Court, which has the final say on the enforcement of the federal constitution in the country. Victor will elaborate a bit more on this.
Okay, so let me just start sharing my screen here.
Yep.
Can you enter your share screen there, Marcelo?
That's right.
So, okay. So, continuing our presentation here, we have one point of tension between our federal executive and states and municipalities. As Marcelo said, most economic measures were taken by the federal executive, but we have conflicting health policies so far. As you can see here on the bottom left, we have Mr. Jair Bolsonaro, who is our president of the Republic. This picture was taken in March 2020, and he was just appearing in public gatherings. He was fostering people to get together to defend democracy in his terms, trying to get business back on track. And on the other hand, states and municipalities, you can see here on the bottom right, Mr. João Doria, he's the governor of São Paulo state, our biggest state in Brazil, in which more or less 40% of our population lives. Yeah, he and other governors and other mayors from municipalities have adopted strict social distancing policies. And we can see this conflict between the federal level directives and state and municipal authorities' policies. We also have another point of tension in the Brazilian separation of powers regime, and it is about on the one side, the federal executive, and on the other side, the judiciary. Here in this small picture, we have our Supreme Court in a remote session, and the court has issued several decisions against federal government. We have decisions stating that states and municipal authorities have full authority to develop, to implement their own policies in the current crisis. We have the constitutionality of provisional measure of a statute with legal force, with emergency power legislation, who was declared unconstitutional, which was about data sharing with companies to the public federal executive authorities. And it was also interesting that the Supreme Court has issued a decision that public agents, that officials must have empirical backgrounds and empirical rationales for their decisions, which was, as you can see, more or less a problem here in Brazil. And just to briefly finish our presentation, what about Congress? What's been doing during this crisis? Both chambers of our National Congress, the House of Deputies, and also our Federal Senate, they have been working remotely. You can see here on the right a remote session of Federal Senate. Both chambers are working, but only their floors, and two special committees to control the executive measures that are being taken during the crisis. We have a kind of speed up legislative process, and this gives rise to just raises questions about accountability and participation concerns. We do have here the technological infrastructure to allow citizens to participate in the legislative process, but so far, as we can see in practice, this has not yet happened. And maybe one key point of Brazil political landscape right now is that we have a small coalition in parliament in favor of government. So we can say that President Bolsonaro has not yet so far gathered enough public or political parliamentary support for his measures. He issued more or less 30 provisional measures or emergency legislations for the crisis. Some of them were adopted, were ratified by Parliament. Some of them were not. And maybe to finish our presentation, I would like to point to this point that our President of the Republic, Mr. Bolsonaro, has been facing real opposition in the Parliament and also in the judiciary. So maybe, at least happily so far, we have not seen a political disruptor or institutional disruptor in Brazil. That's it, Helen.
Thank you very much both for keeping on time and for presenting quite an interesting aspect to COVID. When you see the executive at federal level and then at state level, I don't know, fighting, rugby playing, I don't know, Ronan can give me the right term, tackling each other. It's quite interesting to observe. You have quite a bit of questions. Let me start with the first one. Do you have confidence in the parliamentary and judicial arms of the state in protecting citizens from the stupidity of the executive in that crisis? Are they doing their job well as a check and balance in the system? And that's a question from Ronan Cromakin, Dr. Cromakin.
I do think that the judiciary is working quite well in Brazil. Of course, there are lots of criticism against the judiciary, but the Brazilian Supreme Court is acting as a powerful court against some absurdities issued by the federal government, and not only the federal government, but by some states and municipalities also. So I do believe it's acting quite well, it's working well. It's not to say that it's immune to criticism. It's not to say that we are 100% confident in the judiciary, but I think that's a good balance between the powers. I don't know if Victor has another view, but.
Yeah, I totally agree. If Melissa would also like to speak, I'll be invited. But I think that so far the judiciary has been playing a very important role of blocking some more or less dangerous emergency legislation from President Bolsonaro, and so far has been done, on a whole, a good job.
Thank you. Can we move on to the next question by Murat Ongel to Mr. Pinheiro? Can you deepen the mandatory scientific justification point in your presentation, or give some examples, please?
Yeah, this decision by our Supreme Court was taking a case in a legislative emergency measure about the responsibility of public agents. Federal government has been trying to restrict the personal responsibility of agents who are taking decisions in the crisis, and the Supreme Court has issued a decision that, considering the uncertainty of which measures in terms of health and economic measures should be taken as the adequate ones to tackle the crisis, the Supreme Court decided that the responsibility of public agents can be restricted, can be reduced, but they must, on deciding such questions in health, especially in health and economic questions, they must provide substantial scientific, empirical evidence about their decisions they are taking. They may be uncertain about which consequences will happen in the future, but the scientific background should be justified in their decisions.
So I think you make a very good point that somebody else made as well beforehand. I think it's quite interesting to see the role of scientists in decision making, and quite interesting to see, I think for the first time in my view to that extent, to see the legal community basically expressing the regulations made by the doctors as interpreted by the executive. So thank you very much. It's a wonderful, let me just make sure that any other question is answered. Yeah, thank you very much for now. There's a couple of questions, we will come back to them at the end, but thank you both very much for presenting the Brazilian experience in such a detailed and critical manner. Thank you both. Shall we then move on to our last, again, joint paper with the COVID-19 in Hungary and Poland theme, extraordinary situation and illiberal constitutionalism. And it's my pleasure to invite to the floor Professor Timea Drinozzi, whom I've known for, I'm not even going to say how many years, because that would be too revealing, and also Dr. Agnieszka Ben-Kachala to talk to us about Hungary and Poland. Over to you.
Thank you very much, Helen, and thank you, Ronan, Itai, and everybody else who was involved in the preparation of this meeting. And now I'm trying to share my screen. And if it is there, I believe it is. So in this short speech, we first would like to put our article into context. Agnieszka will do that, and later on I will make a short summary of our findings. So Agnieszka, please.
Yes, thank you very much, and I would like to thank you also, all of you, for inviting us and for attending this webinar. During our research on illiberal constitutionalism in Poland and Hungary, which is financed by the National Science Center Poland, we try to conceptualize what illiberal constitutionalism means for the theory and practice of constitutional law and constitutional change. We perceive illiberal constitutionalism as the functioning of a public power that upholds the main constitutional structure but lacks a normative domestic commitment to constrain on public power. By doing so, however, to a certain extent, it remains within the boundaries set by EU law and politics, as well as international minimum requirements. In these states, all elements of constitutional democracy, such as the rule of law, democracy, and human rights, are observable. yet none prevails in its entirety. Illiberal constitutionalism is not the opposite of liberal constitutionalism and does not equate to authoritarianism. It departs from the former and tends towards the latter. You may see the diagram at your screen, of course. Thus, constitutional democracy still exists, but its formal implementation overweights its substantial realization. As the last 10 years in Hungary and 5 years in Poland show, illiberal legality means the hollowed out European rule of law, which accentuates the instrumental and opportunistic use of domestic law in both legislation and the application of the law. Illiberal legality involves that every situation has the potential to be exploited for political gain. Another characteristic is that the weak constraint that European rule of law weighs over domestic public power. Illiberal democracy in this context means the formal manipulated, profoundly majoritarian and non-inclusive democracy in which constitutional institutions such as election and electoral rights and principles, representation and accountability, and the central tenets of democratic lawmaking are to a certain extent misused, abused, or neglected. The illiberalization of the human rights regime, which could also have a constraining effect, is a much slower and more gradual process than the remodeling of the rule of law and democracy. First, the positive obligation of the state to provide an adequate legislative and institutional framework for human rights protection is considerably weakened. It is then followed by a decrease in the importance of human rights protection, sensitivity to human rights violations, and tolerance toward otherness. It is accompanied by attacks on politically and economically sensitive rights like media freedom, academic freedom, and the right to assembly. So against this background, Tima talks about how the crisis has been managed in Hungary and Poland, mainly from the perspective of legislative practice. Thank you, Tina. It's your time.
Yes, thank you, Agnieszka. So what is most important is that since the crisis started in Europe, Hungary has using and abusing its fundamental law, while Poland has kept disregarding its constitution of 1997 and at the same time creating its new illiberal and invisible constitution. So there is nothing new under the sun. While in mid-April 2020, it was still an open question if the management of the COVID-19 emergency already pushed or could push these countries into authoritarianism, now it seems unlikely. What has been expected is a turn to the pre-COVID illiberal constitutionalism, which, however, is in a worse shape than it was in March. So first, as for the return to illiberal constitutionalism, what we can observe is the same game our illiberal leaders have always played. We have to say that despite the emergency regimes of the Hungarian and Polish constitutions, the legal systems have not really been prepared for a pandemic like COVID-19. Illiberal populist leaders saw their opportunity, but they took it differently. The Peace Party, together with the Sejm, did their best to facilitate to hold the presidential election as originally planned at the beginning of May and amid the pandemic. To this end, they did not introduce the constitutional emergency, but created a statute-based one. Eventually, however, they backed off the adopted and criticized electoral law was invalidated by a new one, and the vote to the presidential election also was postponed to like this Sunday, if I'm not mistaken, which actually did not really turn out too well for Mr. Duda. In Hungary, the unlimited authorization for the government was terminated by the end of the constitutional emergency in mid-June. On the other hand, a newly created statute-based emergency was introduced in which the government has much less power than in the previous constitution-based emergency. It is also true, however, that the parliamentary oversight is ensured neither in this new statute-based emergency. On the other hand, an effective oversight in the Hungarian constitutional and political reality is really an illusion. Second, about our inquiry on the nature, form, and content of the Hungarian and Polish emergency legislation. So you can see first about the nature and content. The introduced emergency and some emergency laws and some other measures in both states are unconstitutional, regardless of the decision of the Hungarian Constitutional Court on the crime of spreading false information. What we can mention here, as you can see, is the Coronavirus Act and some decrees in Hungary, the newly created statute-based emergency in Poland, and the Polish ban on the exercise of the right of assembly. This latter belonged to the intention to adopt unconstitutional legislation facilitating the presidential election to be held in May and then later in June, and favoring the incumbent president in his campaign. As for the form, in the Polish state...
Sorry, you have 1 minute.
Oh, okay. Now then I can give a very short summary about the form. As you can see, because of the difference between the Polish and the Hungarian emergency, in Poland, a statute-based emergency was introduced, so the parliament managed the crisis, while in Hungary it was the government, or basically the prime minister. And what is the consequential effect of that is that the socially distant legislation is different in Poland and in Hungary. So while in Poland, the body of law doesn't change, so whatever the parliament adopted, they amend statutes, while in Hungary, the governmental decrees do not amend statutes, they just suspend their application. And while it is difficult in Poland to identify which are the virus-related legislation because they are integrated in the ordinary body of law, it is quite easy to be done in Hungary. So as I had only 1 minute, there have been many other things we can discuss about Hungary and Poland. I would be happy, and we would be happy to answer your questions. And thank you very much. Maybe one sentence reminder, I feel it very important to say, the leaders of Hungary and Poland will keep pushing their limits, and they will not stop doing so. So this is one of the lessons which we can learn again from the management of the COVID-19 crisis. Thank you.
Thank you both very much, and apologies for being so rude
That's
as
fine.
to interrupt, but I'm sure there will be questions in the end. The first question for you by Ronan was in front of me. It's now gone. Bear with me. Oh dear. As I understand it, as I remember it, the question was, we've seen that the Brazilian Supreme Court has been quite effective as a brake on the executive. Do you think this could be true in Hungary and Poland?
No. No, given the packed constitutional court in both states, it is not. What you can see is that we have only one decision right now about the constitutionality on one part of the Coronavirus Act, which amended the criminal code on the spreading of false information. And now the Constitutional Court said that it is fine, and so that you can be jailed, and that it could even have a chilling effect on academics and the reporters. But it is interesting in this illiberal constitutional context, because the Constitutional Court said it is fine, but then it set some constitutional requirements. So this is, if you remember our second slide with the figure of how we theorize illiberal constitutions, this is maybe one of the best example, but answering the question, no.
So to follow up on the question, what would be then a good break? How do you resolve this?
We can't. There should be a new election. The government should be changed. I mean, the majority in the parliament should be changed, but we don't see, at least I don't see any chance for that in Hungary. And I'm not sure about Poland. So maybe Agnieszka.
Yes, thank you. Well, I agree with Tima because these are our common observation. I would say maybe something more about our judiciary or common courts. Maybe they are now so, maybe they could help somehow, but I am not sure how it will be in the future. Yeah, but for now, I think that maybe in some way courts, but we will see.
Thank you very much, both of you. I am clapping each and every speaker, so thank you very, very much for a really eloquent presentation. I think it is an aspect to constitutionalism that I certainly hadn't thought of before, and it's quite interesting, I think, for those of us to think that our constitutions are different, to really get into depth and assess and find out whether ours might be more liberal as we thought before. So can I then go back to different questions, please? And for all speakers, at the end of your presentations, yes, for speakers, is it better for the rule of law to formally declare a state of emergency and use these powers, or not to do so? So can I ask those who have not answered the questions? I think Klaus and Felix have answered it. What do you think? Is it better for the rule of law to formally declare a state of emergency or not? Speakers, feel free to unmute and talk.
I am muted.
Yeah.
It is a very interesting question, and I think that we have to distinguish between liberal constitutionalists and illiberal constitutionalists, because in the paper we had this assumption that we have a really nice constitution, both in Poland and Hungary. It's very detailed in regulating its emergency regimes. And then what is happening, Poland does not even introduce it, even though there are certain guarantees which are necessary. So that is why I'm talking about the constitutional regime, because we have who does what and when, and there is also a time constraint. So every requirement, every conditions are there. But Poland just simply didn't use it, and Hungary abused it. So no time limitation in the Coronavirus Act, which actually gave the authorization to the government, the unlimited authorization in time to the government, but also in content. So I think the first point is that you have to distinguish between constitutional regimes, and you have to know how they function in order to answer the question. Thanks.
Thank you. Yes, Patricia. Can you unmute yourself, please? Sorry. I can hear you, but very low. Right, but it is too high now. So if you wouldn't mind lowering your, yeah, perfect.
Okay, I just wanted to add that even in liberal democracies, I think it is better to declare an emergency, just to show that this is an extraordinary situation, and that the means that you take, the measures that you take to fight it are temporary, and that you need, I mean, in these times, you will more easily say, okay, let the government just do, because we don't know what's going to happen otherwise, and someone has to take control. But you must stay aware, even in whatever democracy that you live in, that this is an extraordinary situation, that you need some control now or later.
Thank you. Thank you. Can I move on to a question for Professor Adazi Kum? What if any reactions has, what if any reactions has the African Union had to Ghana's misusing the constitutional provisions meant to govern public health crisis as a pseudo emergency decree in the way that you described?
I responded to that privately, but the AU is yet to make any comments on that. The African Union is yet to make any comments on that.
We would very much like you to share your answer, please, if that's okay.
Yes, I responded that the AU is yet to make any comments on that, so there isn't any.
I see. Thank you very much. So not yet. There is one question from Afina Stafila to Klaus. And what she's saying, it keeps jumping. And what she's asking is, how could the principle be fluid if it produces results that are over 70% secure?
I must confess, I did not get it exactly. 70% insecure or secure?
Sorry, secure. Afina has sent a question, and I'm just trying to find its actual origin. I think it was along the lines, bear with me.
I'm sorry for that, yeah.
No, it's my mistake. I should be more, yes. Well, the question has been answered.
It's on precaution principle is in most cases based on scientific evidence.
Yeah.
And leads to a high standard of probability, more than 70%. The event is true. How can the principle be arbitrary? Yes, so maybe you can also apply it to situations where this 70% threshold is not met. So I cannot judge in detail what happened with the precautionary principle in different states. So I say that you do not have to resort to the precautionary principle if you are safe. So if you are safe, depends when are you safe, 70%, which degree of the probability is vital. But so I hesitated because I'm afraid that on the one hand, the precautionary principle lends itself to abuse. So we can bridge lacks of deficits of evidence. But on the other hand, we should not make it a taboo. So we are quite sure that states will resort to the precautionary principle if necessary. So I gave you the example. Try to think of people who refer to the precautionary principle when it comes to to preventing crime. So we would say this is an illiberal state. So we cannot accept sort of preventive custody, for instance. So we must look at the precautionary principle as a more general principle, and so I only say there are some risks with the precautionary principle, and therefore it must be governed by the overarching principle of proportionality, for instance. So it is, I'm two minds about it. On the one hand, I say I must refer to it. I cannot close my eyes on the precautionary principle, but I do not want to recommend it to make very liberal use of this principle. So there are two answers to this, but I'm not so sure that that we can rely on the precautionary principle in any case.
Thank you very much. This makes a lot of sense. A question from Itai Barsimantov. So it's for the Brazilian team. He says, often the fear is from a populist head of state overplaying the crisis to usurp powers and leading to democratic backsliding. Here, the president is underplaying the danger. Is that in fact creating a safeguard from autocratic tendencies from the head of the executive, Brazil?
You know, our president is usually, or quite constantly, is flirting with the idea of a dictatorship, some say. Okay, so there is this risk, but I think the institutions here in Brazil, despite of loads of critics, they are working, they're functioning quite well in the current crisis. So it's not there's not a safeguard for our president to go through that path of an authoritarian regime, but of course we need to be alert.
Thank you. Is that the representative view of the whole of the team?
I don't know. Where is Victor? Victor?
Yeah. Just as a very short remark on that. The thing is about Bolsonaro that he's losing political support very quickly in Brazil. Even people who voted for him, as you can speak with them on the streets, they're saying that he is acting kind of irrational during the crisis. So he doesn't have much support in Congress, not on the Supreme Court. He tried, during the campaigns, he said that he would pack the court. We have right now 11 Supreme Court justices. He said that he would make it 16 or something like that. And it was very unpopular and he couldn't do it. So as Marcelo told us, he's been trying in some way to change the institutional framework in Brazil, but so far, happily, he couldn't make it.
And just to add a comment, and usually our president, he appeals to his political platform, which is composed partially by the far right spectrum in Brazil. So this kind of discourse is appealing to those kind of people. So he keeps saying and flirting with this kind of argument.
Thank you. Thank you very much. There is a question from the audience from Kabi Gabson. Thank you for the response. Second question to Professor Adatsi-Kum. Please, if she was tasked to chair a committee to reform these emergency laws passed, what would she do differently or same? Mame, would you please unmute yourself, please?
Yes. So I think if you are supposed to look at the emergency legislation, you're supposed to look at it in terms of the context of the constitutional context of each country, because for the Ghanaian situation, using the state of emergency would have been better than what we have now because of the limitations that the Constitution provides compared with the unrestrained powers under the emergency legislation. But if we find ourselves in a country or in a jurisdiction where the special emergency law rather places a lot more accountability on the president or on executive power than the Constitution provides, then it would be better to go for the special legislation. So it's on a case-by-case basis.
Thank you. On that note, can I start concluding this very popular webinar? I was interested to see that we had such a high number of participants, and to that effect, let me pass on the many thank you notes that I received from attendees via the questions and answers. I'm not sure the panelists can see them, but let me join each and every one of those messages to say thank you all very much indeed for fantastic presentations, opening new ground to different aspects of the COVID crisis. Although we covered quite a lot of ground today, there's the opportunity to explore even further. And let me remind you of the next webinar within the series, the second one, which is going to be on Wednesday, the 15th of July at 5 p.m. UK time. And Itai Bar-Simantov will be chairing that one. You can register again through the Bingham Center website at the start of next week. Until then, we have 6 full papers now published online at Taylor and Francis, and there is a link there that will be passed to all of you. The webinar is indeed recorded, and so you will be able to come back and listen to the speakers again. I know I will be doing the same. Before we close, I would like to thank all of you for being here. I think it is quite important to exchange views and feel close to the scientific community at a time when closeness is considered to be a sin or an offense, depending on where you are. What you will now watch is a slide from the Bingham Center and the British Institute of International and Comparative Law. This is a slide that invites you to donate, and let me say, as somebody who is an external to BICL, so a disclaimer there, to say that they are funded by us all, and their survival and flourishing is a tool that facilitates the type of discussions we've all enjoyed here. So onto the slide now, and great many thanks to each and every one of you.